My name is Gemmil. For the last 25 years, I've been a practicing attorney in the state of California. For the majority of that time, I've represented injured workers in workers' compensation claims. My company, Advocates for Employers' Rights and Advocates for Contractors' Rights, is dedicated to assisting employers in reducing their workers' compensation premiums as well as their experience mod rate. We are not an insurance company and we are not an insurance broker, but rather we are former workers' compensation attorneys and workers' compensation professionals. The dirty little secret of workers' compensation is that insurance companies would rather pay than fight workers' compensation claims. As an employer, you've probably experienced this firsthand, and you've probably thought, how can this be? Why would an insurance company pay on a claim that they know is not legitimate? The answer, ladies and gentlemen, is very simple. The money's paid by an insurance company to investigate and defend a workers' compensation claim cannot be used to justify a rate increase to you. The money spent on investigators, the money spent on their attorneys, the money spent on discovery of the case cannot be passed along to you, the employer. However, the money spent to settle a workers' compensation claim can and is used to justify a rate increase to you. Not only does it increase your insurance premium, but once again, it also increases your experience mod rate. Unfortunately, a conflict of interest exists between you and your workers' compensation carrier, and even at times, between you and the attorney hired by them to represent your interests. We contact the workers' compensation carrier. We contact the defense attorney. We remind them of their fiduciary duty to you, to put your best interest ahead of theirs. And we also notify the insurance company that if they fail to do so, that in my opinion, they will be guilty of insurance bad faith. We remind the defense attorney that if they fail to make those recommendations I've mentioned, that they will be guilty of legal malpractice. And we advise both of them, ladies and gentlemen, that we will sue them for insurance bad faith. And their defense attorney will be sitting at the counsel table in the defendant chair right next to the insurance company if they fail to do the right thing. In short, we demand that the insurance company, for once, put your interest, the employer, ahead of theirs. Trust me, ladies and gentlemen, without an advocate in your corner, it will be business as usual for the insurance company. Cases will be settled, insurance premiums will continue to go up, as well as your mod rate. With our assistance, however, we will contact the insurance company, we will monitor the claims, we will appear at the hearings, and we will give you a voice. Unfortunately, up to this point in time, employers, as a general rule, have not had a voice in the system. Insurance companies and their attorneys don't even recognize them as clients. But without assistance, ladies and gentlemen, not only will you have a voice, but you'll have an advocate. You'll have an advocate that will vigorously defend your interest, that will vigorously push your interest, that will remind the insurance companies that business as usual has come to an end, that with at least your claims, they will do the right thing and they will put your best interest ahead of theirs. If you would like more information about how our company can be of assistance to you, please refer to the phone number and website as listed below. Thank you very much for your time.